Now we are really in that wrap-up mode of putting everything together in the mind. So, if you could help us do that and formulate what you have.
It's all set out in the note that I have given.
Excellent. Okay.
So, Mulaz, we don't have to really travel anywhere else.
Just formulate it.
That's right. Mulaz, I just wanted to mention one other broad point, Mulaz, before your Lordship will allow me to respond to your Lordship's query a little later, if your Lordship permit me to do that. I just wanted to make one other broad point, Mulaz. And that is, if your my lords look at Article 180, sub-article 1. Sub-article 2. 1 or 2, Mulaz, both may be read together. Your Lordship has that. While the office of a speaker is vacant, the duties of the office shall be performed by the deputy speaker, or if the office of the deputy speaker is also vacant, by such member of the assembly as the governor may appoint for the purpose. The governor may appoint for the purpose would be on the advice of the council of ministers. And during the absence of the speaker from any sitting of the assembly and deputy speaker, or if he is also absent, such person as may be determined by the rules of the procedure of the assembly.
So or if no such vacancy, second deals with absence.
So, Malaj, either way, Malaj, if both of them are absent or for some reason cannot participate, somebody else will be appointed. Right? Now, in this context, look at paragraph 6.2 of the 10th schedule. They have to be read together. Just another broad point I wanted to make before your lordships. The proviso to 6.1, Malaj. I'll read 6.1. If any question arises as to whether a member of a house has become subject to disqualification under the schedule, the question shall be referred for the decision of the chairman, or as the case may be, the speaker of such house, and his decision shall be final. Provided that where the question which has arisen is as to whether the chairman or the speaker of a house has become subject to disqualification, the question shall be referred for the decision of such member of the house, as the house may elect in this behalf, and his decision shall be final. So what is it that I am canvassing before your lordships? That there can be no hiatus. Right. If there's a deputy speaker against you, we've given notice. The disqualification proceedings don't stop. That's my first word. At the outset, I made that submission to your lordship. They've not answered it. That's why the order of this court on the 27th, saying that, all right, you can file your reply, Malaj, is as well as the proceedings won't go on. Is as if their proceedings won't go on. Because somebody else would have presided over the house and proceeded with the disqualification. This is the problem with the Nabam Rebia judgment now.
So it gets referred.
And the deputy speaker cannot decide.
Until the decision of the committee of the house is taken, what happens in the interregnum?
Which decision of which committee?
This question as to his disqualification is referred to the committee.
Yes.
Right? Committee is looking into the matter. In the meanwhile, what happens?
No matter the person elected as the speaker, then or chairing the house will decide. There is no committee.
Read with 180.
Yes. There is no committee. So therefore, Malaj, all this not dealt with in Nabam Rebia.
What's the ground for removal of this speaker?
That's the other point I wanted. No ground. I'll show your lordship that notice. Nothing.
So that was not a disqualification. He was not being removed under
disqualification
under the 10th schedule.
Correct. Therefore, Malaj, that notice was an ab initio void.
No, but they can always say that, look, we don't have confidence in the speaker.
No, they can't, because that's the removal proceedings are under 179. I showed your lordship Shakhtar and call, which says it has to be for reason. I showed that to your lordships at the outset. Because removal is stigma, which is why Malaj is allowed to be in the House, allowed to participate in the proceedings and respond to the allegations. It's not a no confidence. No confidence is no reasons. It's a removal. Again, not considered in NABAM. So these are very serious questions. That's another broad point I wanted to make, Malaj, before I proceed.
Yes.
Anyway, now kindly come to the propositions that I have placed before your lordships. Malaj, it's already with your lordships, I hope. My submissions, the rejoinder submissions, Malaj. Document number. It's not numbered.
A what?
In rejoinder on 14th of March.
That is A4 is Mr. Sibbles, is it?
Yeah.
Petitioner rejoinder written submissions.
Yes, that's correct. So, Malaj, all that I've set out now so that I don't have to, Malaj, wherever necessary, I'll refer to the document, otherwise not, Malaj, because your lordships have actually gone through all the documents. But, Malaj, first I will deal with item number, Malaj, page 2, 3, 4, 3 and 4, Malaj, the submissions made by the other side, which I'm going to deal with presently. At page 2, Roman small 3 and Roman small 4. Their argument was, Malaj, as your lordships will notice.
Page 2.
Yes, Malaj, 3 is the respondents have not incurred disqualification under the 10th schedule because their claim is not that there is a split, but that they represent the Shivsena. That's their case, which has been decided by the Election Commission in their favor, that there is no distinction between the legislative party and the political party, and the 10th schedule does not stifle the right of the legislatures to dissent. That's their argument. I hope I have encapsulated, Malaj, accurately. Then next 4, respondents have not incurred disqualification under 2(1)(b) of the 10th schedule because the respondents had appointed their own whip, Shri Bharat Gogavle, on the 21st of June, and they have obeyed the whip issued by Gogavle. The legislature party has the right to appoint the whip, relying on members of Maharashtra Legislative Assembly disqualification on grounds of defection rules. I hope, Malaj, that's a correct articulation of what they've said. Now, Malaj, our answer, kindly straight away we'll come to the heading, Malaj. I first deal with the governor.
Why don't we deal seriatim with your submissions, actually? A, governor, from A onwards.
All right.
That
I can
might be
do that.
better
I
so
thought
that
I
you
would finish the governor first and then.
Yeah, exactly. That is A at page 3.
Three.
Capital A.
Capital A, yes. A,
Governor's decision.
that's correct. Give me a minute. Yes. It's capital A. Non-recognition of factions under the Constitution. That's the one, Manoj?
Governor's decision.
No.
Page 3, page 3.
Page 3A.
Page 3 bottom. Top.
Para 5.
Para 5. Yes.
Oh, okay, yes. Yes, governor's decision. The respondents contend that it is the duty of the governor to hold a floor test. The only constitutionally ordained forum is the assembly, and further contend that by whatever process or means the governor can gather the information that was required, which raises a credible doubt as to the majority of a government in power. In support of this contention, reliance was placed on the law laid down by this Honorable Court in Bomai and in Shivraj. That's their case. It is respectfully submitted that the respondent's contention is misconceived and is based on a misreading of the law in Bomai and Shivraj. It is settled law that the governor's decision to call for a trust vote is subject to judicial review, and the same is liable to be quashed if it is based on extraneous considerations. In Shivsena Chauhan, whilst holding that the exercise of discretion by the governor to call for a floor test is subject to judicial review, this honorable court observed that, quote, the court is entitled to determine whether in calling for the floor test, the governor did so on the basis of objective material and reasons which were relevant and germane to the exercise of power. The exercise of such power is not intended to destabilize or displace a democratically elected government, accountable to the Legislative Assembly and collectively responsible to it. The exercise of the power to call for a trust vote must be guided by the overarching consideration that the formation of the satisfaction by the governor is not based on extraneous considerations. That's the heart of the decision. It's not merely that he cannot call for a floor test, but the reasons on the basis of which he must call for a floor test must not be extraneous and irrelevant, which is what I tried to show yesterday to your lordships. Then, Malaj, the governor cannot resort to whatever process or means to gather information which casts a doubt on the confidence enjoyed by the government in the assembly. The governor's satisfaction has to be based on relevant and constitutional considerations. In the present case, the governor, in his decision on 28th of June, arrived at his satisfaction that the government headed by Uddhav Thackeray had lost the trust of the House on the basis that, and I quote, majority of Shivsena MLAs have given a clear indication on behalf of the Shivsena legislature party that they intend to exit from the Mahavikas Aghadi government. That's the heart of the matter, Manas. That's the decision of the governor. The 34 of them have come to me, and I recognize them. If that's germane to his decision-making, constitutionally germane to his decision-making process, he's right. And that's why I said to your lordships yesterday, and I gave your lordships the Sarkaria Commission, Manas, that the governor can only deal with alliances. He can only deal with parties. He cannot deal with individuals. Otherwise, there'll be havoc. Any three people from any party will go to say that now you must call for a floor test.
All right, let's read ahead so that we'll get your formulation.
Yes. Firstly, it is respectfully submitted that the resolution of 34 members of Shivsena, which is relied on by the governor in his decision on 28/6, does not state that the 34 members intend to exit from the Mahavikas Aghadi government. Moreover, only 8 out of 32 members were ministers of the government. The rest were not ministers. So how could he say, Maharaj, they want to move out of government? Only 8 of them. Thus, the governor has misread the resolution of 34 Shivsena MLAs as demonstrating their intention to exit from the Mahavikas Aghadi government, and consequently his satisfaction about the lack of confidence enjoyed by the government is based on extraneous and irrelevant considerations. Secondly, para 7 of the governor's decision makes it clear that the governor based his satisfaction on a claim made by a majority of Shivsena MLAs against the government formed by his own political party, their own political party. So on what constitutional basis can the governor recognize, whether minority or majority, a faction in the legislative party to direct a floor test? It is respectfully submitted that the governor has no power to recognize a majority faction of a legislature party, and on that basis come to a prima facie conclusion that the government has lost the confidence of the House. By doing so, the governor enters the political thicket outside the domain of his constitutional duties and facilitates the toppling of an elected government, which is impermissible in law. Paragraph 3 of the 10th schedule, as it stood prior to its deletion, stipulated that where a member makes a claim that he and any other members of his legislative party constitute a group representing a faction which has arisen as a result of a split in his original political party, and such group consists of not less than 1/3 of the members of such legislature party, the same would constitute a valid defense in a disqualification petition filed against such members under paragraph 2 of the 10th schedule. Whereas my lord asked me this, a question related to this. Whereas paragraph 3 said not less than 1/3. It could be 75%. So it envisaged a situation where the majority would go away, a minimum being 1/3, and gave that protection. After it was deleted, neither 1/3 nor 75 will get protection. That's the consequence. And Milad, if your lordship reads paragraph 3 with me for a minute, well, it's very interesting. Original paragraph 3. Statute compilation, PDF page 50. Where is that? Statute compilation. Yeah, yes, I got it, yes. Yes, now kindly see paragraph 3 as it was. Your lordship has, it's at page 48, PDF 50. My lords have it?
Yes.
Where a member of a house makes a claim that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in the original political party. Any such group consists of not less than 1/3 of the members of such legislative party. He shall not be disqualified under subparagraph 1 on the ground that he has voluntarily given up or that he has voted or abstained from voting. From the time of such split, such faction shall be deemed to be the political party to which he belongs for the purposes of subparagraph 1 of para 2 and to be his original political party for the purpose of this paragraph. So what's one thing is quite clear, that the paragraph 3 dealt with factions. An argument to say that I am the party is contrary to the constitutional framework. Because he is not the party. Because the party is registered, Malad, under section 29A of the Representation of Peoples Act. The office bearers of the party are communicated to the Election Commission. And whereas the constitution as accepted is the final document. He can't now say, I am the party, because the party with the Election Commission and the party with the speaker is only the members of the legislature belonging to that political party. So you can't say, I'm the party. So that proposition is unfounded in constitutional law. So I'll read, I go back, Malad, to my submissions. So, Malad, I go back to my page 5. Thus, paragraph 3 as it stood, I'm sorry, you also have that?
Yes.
Yes.
Thus, paragraph 3 as it stood recognized a faction of the legislature party arising as a result of a split in the political party. And Malad, your lordships have now read all the documents. Till July the 4th, is there any reference to any split? No reference. No mention of split. With the deletion of paragraph 3 of the 10th schedule by the Constitution 91st Amendment, there is no constitutional recognition of a faction or group in the legislature party. Reference is invited to petitioner's written submissions, 160 to 163. Malad, your lordship have it. I've given the page so that it's easy, Malad. The effect of deletion of paragraph 3 from the 10th schedule is that the Constitution does not recognize any faction, whether it consists of majority or a minority of the members of the legislature party. Why? Malad, there's a constitutional basis for that also. I tell you just why. Malad, when I seek election directly from the electorate, I don't seek election in my personal capacity. I seek election on the symbol of the party. In my activity in the House and outside the House, I continue to be a member of that party and must honor the discipline that's imposed on me. So in the relationship between the legislature and the political party has primacy. The legislature party has not primacy. So when you are interpreting the Constitution, you have to give primacy to that political party whose representative I am in the legislature. You can't, in the process, give primacy to the legislature over the political party, which the other side is trying to do, by saying, I am the party. It can be one member of legislature, but can he say, I am the party? So within the constitutional framework, the will of the legislators, in fact, is subject to the functioning of the political party, both inside and outside the House. Now, he can have dissent outside the House, but no dissent within the House, which is why the whip. Because there he represents. That's why Holohon says you can't go against it. That's the rationale for it, Malats, constitutional rationale for it. Then, Malats, a fortiori, therefore, the concept of a faction asserting itself in the legislative party and acting dehors the political party or calling itself the political party is not contemplated by the law, and any such claim will be per se fall foul of paragraph 2 of the 10th schedule. Parliamentary democracy only recognizes alliances between political parties and not an alliance between a political party and a faction of a legislature party. That be constitutional harakiri, Malats. Reference is invited to the order for preference to be followed by the governor as stipulated. Malats, kindly have a look at that page only, Malats. Kindly come to my written submissions, page 101, Malats. Right, 101.
Which file would that be, please?
Petitioners written submission.
Yes,
Petitioners,
101.
written submissions. Page.
Yes. Now, Malats, kindly share. Very interesting. Yes. Yeah. Kindly see page 101, paragraph 240.
Yes.
Yes. It is submitted that the governor cannot recognize the rebel MLAs and of political parties, as that would ring a death knell on the working of a multi-party democracy. The Sarkaria Commission's recommendations approved by this Honorable Court in Rameshwar Prasad also categorically emphasize the importance of sanctity of the party system and states that the governor, in arriving at a satisfaction to invite a chief minister, can only recognize alliance of parties and not an alliance of a party, in this case the BJP and rebel MLAs of another party. In this regard, para 65 of Rameshwar Prasad reads as follows. Para 4.11.04 of the Sarkaria Commission report specifically deals with a situation where no single party obtains absolute majority and provides the order of preference the governor should follow in selecting a chief minister. Now, this is final. What does it say? The order of preference suggested is 1, alliance of parties that was formed prior to the election. So parties, alliance of parties. 2, largest single party staking a claim to form the government with the support of others, including independents. Again, largest single party. 3, post-electoral coalition of parties with all the partners in the coalition joining the government. And 4, a post-electoral alliance of parties with some of the parties in the alliance forming a government and remaining parties, including independents, supporting the government from outside. There is no space for factions when the governor has to appoint a chief minister. Now, if all of Shivsena had gone to the BJP, governor will call for a floor test. If the Shivsena itself had gone. Now, this is cast in stone. Now an argument is being raised, it doesn't matter, and which is why, Malad, I said to your lordship the consequences of it. Malad, supposing 2 or 3 members of each political party who don't form the majority go to the governor and say that support of six of these people reduces the chief minister to a minority, therefore call for a floor test. Well, it would be disastrous for democracy. That's the Airam Gayavaram principle that we gave up. Would 50 members of BJP today, Malad, support Uddhav Thackeray, will he call for a test? So, Malad, the whole propositions, the propositions that have been advanced by my learned friends are all contrary to basic principles of constitutional law. I go back, Malad, to my submissions. So, Malad, para 20. Therefore, the recognition of a faction of a legislative party as the basis to cast a doubt on the confidence enjoyed by the government in the House would be an act of constitutional impropriety and legally malafide. It is respectfully submitted that under the constitutional scheme, a member of a legislative assembly set up by a political party does not have any independent identity in the House. Dehors the political party on whose ticket he is elected to the House. The same is clear from the following. Now, this is important. Kindly see Article 170 of the Constitution and kindly see sub-Article 1. Subject to the provisions of Article 333, the Legislative Assembly of each state shall consist of not more than 500, not less than 60 members chosen by direct election from territorial constituencies in the state. Well, I mentioned that to your lordships yesterday. Delimitation Commission, territorial constituencies, direct election from the territorial constituency. Now kindly come, let's go to item 2. Under 7(1) of the Representation of Peoples Act 1950, the total number of seats in the Legislative Assembly of each state is as shown in the second schedule. Further, Section 7(3) of the Act provides that the extent of each assembly constituency shall be as determined by the orders of the Delimitation Commission made under the provisions of the Delimitation Act. I don't have to read it, Malad. Your losses may take it that that's correct. We'll waste time otherwise. Malad. Then come to 4. The first step in the process of nomination, Section 33 of the Representation of People Act, prescribes that each candidate desirous of being elected to a seat is required to deliver to the returning officer a nomination paper completed in the prescribed form. The provision itself differentiates between candidates set up by a recognized political party and those not set up by the party. That's Section 33. No, let's not read it. That's up. Nobody can doubt what I have said. So otherwise, it'll take time. Next, the relevant rule in the conduct of election rules pertaining to Section 33 is Rule 4, that deals with nomination papers and prescribes that each nomination paper must be completed as per the appropriate form. The appropriate form for the purposes of election to the Assembly is Form 2B. Part 1 of Form 2B applies to candidates set up by the recognized political party. Further, as per paragraph 13B of the symbols order, a candidate is deemed to be set up by a political party only if the political party provides a notice in Form B to the returning officer which contains the endorsement of the political party as to the approved candidate on its behalf. Hence, from the very initiation of the election process, the identity of a candidate for an election is as a representative of the political party by which it was set up. So the primacy is of the party. The legislature has no identity other than being a representative of the party. After the election, Section 66, 67 of the Act require the returning officer, once the counting of votes have been completed, to declare the election result and to communicate the same to the Election Commission and the Secretary of the House. That's very important, Melissa. Kindly see that, 67 of the...
That's okay. I think, you've paraphrased it and there's no reason to doubt it.
The reason is, what he sends is that he has been elected as one C itself says, Malad, declaration of the. Is sponsored by the political party and he has been duly elected. And the certificate also says the same thing. Would you go back to it, Malad? Then, Malad, item 9, corresponding rules of the conduct of election rules are Rule 64, 66, which prescribes 21C, Form 22 to be referred to by the returning officer. 21C deals with the format of declaration of the result of elections by the returning officer, and it explicitly requires the name of the recognized registered political party that has sponsored the candidate to be recorded. The same details are also required to be recorded in Form 22, which concerns the certificate election provided. Therefore, it is respectfully submitted that an elected member of the Legislative Assembly does not have any independent identity in the House except as a member of the political party to which he belongs. Accordingly, the governor could not have recognized any members of the legislature party, dehorsed their political party, and permitted them to make a representation against the government formed by the political party to which they belonged. So Malaj, he should have assumed that they continue to be in the Shivsena and that Shivsena had 52 members and all the three parties together have 152 out of a house of 280. There was no occasion for him to say have a floor test. And undisputedly, in the present case, the group of the Shivsena legislature party, represented by Eknath Shinde, is a faction of the legislature party, albeit a majority. The recognition of a majority of Shiv Sena MLAs by the governor to entertain a doubt about the confidence enjoyed by the government is in the teeth of the provisions of the 10th schedule and of the constitutional scheme related to election of members to the Legislative Assembly. Therefore, governor could not have asked the government headed by Uddhav Thackeray to seek a trust vote on the floor of the House on the 30th of June on this basis. The governor's decision rather placed a premium on the unconstitutional acts of a faction in the legislature party, allowing them to topple an elected government. He knows because he's not a member of the assembly, but he is part of the legislature. So he knows. So he went outside the scheme of the 10th schedule as well as the scheme of the constitution to recognize a faction. Majority or minority doesn't matter. The governor is knowing fully well that a faction of the legislature party cannot be recognized under the constitution.
Sorry, just to pause here. According to you, suppose there is a split, which is now, of course, not recognized.
Yes.
So, what would have been a split under the unamended provisions of of the 10th schedule? But there is a group of legislators who would otherwise, who have otherwise left the. They say we have withdrawn support.
Correct.
Right, whether they withdrew support here or not, that you already made your point. Now, they will incur a disqualification because there is no split which is recognized by the 10th schedule now.
Yes.
Can the governor not then look at the numbers and say that, assuming that these people say that we have left, whether they incur a disqualification will be decided by the speaker, but this conduct of these people in doing something which is contrary to the 10th schedule also is liable to affect the strength of the house and the strength of the number of parties in that house, or the strength of the party in that house. Can he not do that?
No.
Because your argument is he can't do that at all.
No, forget Mullah, the majority. This can happen, Mullah, where 2 or 3 or 4 members of each political party can do the same. What you're doing is, Maharaj, when there was no 10th schedule, what used to happen? The same thing. What my Lord is putting to me used to happen when the 10th schedule was not there.
Right.
So you are going back to a state where the 10th schedule is not there. That's my answer. Because that's exactly what your lordships are putting to me. Can't the governor, looking at the fact that these people now say they want to withdraw support, they may be disqualified. That's a separate issue.
Then your submission would be that the governor can't call for a trust vote in oblivious to the provisions of the 10th schedule.
No, forget the 10th schedule. He can't call for a trust vote, Maharaj, by recognizing a faction in a political party which has no identity, which has no constitutional identity. That's my submission. Maharaj, your lordships are now looking at them as a group. They are not a group, they are individuals. There is no concept of a group within the legislature. Each is an individual. And government formation is based only on alliances. And therefore, Maharaj, calling a trust vote has to be based also on alliances, if it's been reduced to a minority. That's accepted now by Rameshwar Prasad, Maharaj. They could have followed, Maharaj, the Madhya Pradesh model. Resigned. No, but they wanted to be chief ministers and posts, Maharaj, so naturally, Maharaj. they could have followed the other model. But that also is a constitutional issue which one day your lordships will decide. That's also another issue. The collective decision to resign as a group, well, is something which is very suspect in constitutional law. Suddenly, all of them together one day decide we all must resign.
This is in line with Kyoto, unless we question Kyoto.
Well, I have always questioned it. I have always questioned it, but that's another issue, Maharaj.
But it also has a bearing on coalition governments,
Yes.
particularly regional parties.
Yes.
Regional parties, this argument could sometimes be very dangerous also, because there is absolutely no freedom in the party, except for one leader. Many a times it's a family which runs it, and there is no scope of anybody else coming into the fray
Well, in fact,
and setting up an alternative, because it's impossible.
Well-
Virtually, we are interpreting the constitution to say that it is just not possible for any legislators.
Well, in fact, this has been my grievance. What happens, Maharaj, in the United States and then the UK, Maharaj? A president, Maharaj, of the Republican Party will reach out to Democrats to get a bill passed. The insurance, actually, Barack Obama had to reach out to the Republicans for his insurance bill. And in the UK, the same thing, the Conservative Party or the Labour Party reaches out to the opposition members. There's no such thing as defection. This is a problem. But anyway, Maharaj, we are in another era.
Yeah.
At the moment, we are on the law as it stands today. So we go back to the Gayaram regime, where there is no 10th schedule, and you can actually move the governor for toppling any government you want at any time you want. Yeah, a few people. Maharaj, there is an NCP case where only four people of the NCP, Maharaj, actually went away. There were only 4 members. All of them went away. So it can happen.
So according to, going back to the Sarkaria Commission report, which was relied upon in Rameshwar Prasad, this was a post-electoral coalition of parties.
That's correct.
Of course, with the support of some independents as well.
Yes.
So according to it is only if any one member of the alliance and
Shifts.
or one member of the coalition shifts,
That's right.
that the governor can then say that, look, as a result of one party in the coalition, one member of the coalition having shifted,
Correct.
or ceased to back the government. Therefore, I feel now your vote in your confidence in the House,
Yeah.
the confidence of the House in your government is now liable to be affected. Therefore, I call for a trust vote.
Therefore, he is not concerned with the 10th schedule at all, Maharaj.
Right.
With the greatest respect.
Right.
Governor is not concerned with it. That's a separate proceeding. Whether they'll be disqualified, they may not be disqualified. If they vote against the whip, within 15 days, I can condone it. Or if you have sent notices to 16, the others may say, now I don't want to lose my membership. They will come back. That arithmetic and that, the consequences are not relevant as far as the governor is concerned or even the court is concerned. Court is to judge the act of the governor on the 28th of June, whether that was right or it was wrong. And I might say this to your lordships, when we enter this courtroom, we are in a different aura. We come with hope, with the expectation that you are the only hope in this country. Power, if you look at the history of civilization, all injustices are based on power. Whether it was the execution of Socrates, why was he executed? He was executed because he didn't believe in the Athenian gods. He was executed. The same thing is happening today. Not in that sense. Where do we go? Therefore, this court's history has been so phenomenal, and your footprint is the largest around the world. You are the beacon, the hope of 1.4 billion people. And you can't let democracy be destabilized in this callous, uncouth fashion. I'm sorry, Mullah.
But then taking your argument to its logical conclusion, that means that the governor cannot really have regard to any individual movement of a group or a number of MLAs or MPs.
That's Bomai, Mullah. Yes, exactly. Para 88 of Bomai says that.
Movement lies within the province of the Speaker under the 10th schedule.
Internal dispute he can't deal with. Para 88 of Bomai, Mullah. Intra-party disputes he can't deal with. It's in my note. I succumb to it.
All right, let's go back.
Yes, Mullah. Sorry. So, Mullah's decision of the governor is accordingly liable to be struck down. It is respectfully submitted that the respondent's reliance on the decision of Bomai to contend that the governor is duty-bound to order a floor test without regard to the pendency of disqualification petitions is totally misplaced. The respondents particularly relied on 119 and 121 for Justice Sawant's opinion and paras 391 and 395 of Justice Jeevan Reddy's opinion, dealing with court's decision on the situation in Karnataka. Now, 30 is important. As regards the situation in the Karnataka Assembly, the issue before the court was whether the governor, on receiving letters from certain legislators that they were withdrawing support from the government, was justified in himself coming to the conclusion that the government had lost majority and giving a report under 356 for issuance of a presidential proclamation. It is pertinent to note that the Chief Minister in that case had offered to test the government's majority on the floor of the House. Chief Minister himself, I'll test it. These are the facts of Bomai, Karnataka, which they relied upon. In that context, it was held by this honorable court that in cases where the support to the ministry is claimed to have been withdrawn by some legislators, the proper cause for testing the strength of the ministry is holding the test on the floor of the House, because the Chief Minister said, I am ready to hold that test. And para 3 was there on that day of the 10th schedule. And what did the governor do? 356. It's in that context that Bomai says, which is why I said the other day, these decisions are contextual. There's no general principle that can be applied across the board. There can't be. Freedom of speech is a general principle. How you will actually, recognize it is the context. So, in this connection, it is necessary, I'm quoting, I'm sorry. In this connection, it is necessary to stress that in all cases where the support of the ministry is claimed to have been withdrawn by some legislatures, the proper course for testing the strength of the ministry is holding the test on the floor of the House. That alone is the constitutionally ordained forum for seeking openly and objectively the claims and counterclaims in that behalf. The assessment of the strength of the ministry is not a matter of private opinion of any individual, be he the governor or the president. It is capable of being demonstrated and ascertained publicly in the House. So first you must reach a bona fide, constitutionally valid conclusion that this requires a floor test. and on relevant considerations. If you are able to justify that to the court, then the only remedy is a floor test. Well, let's, the next paragraph, I just read the highlighted portion, para 391 at the bottom. Whether the Council of Ministers has lost the confidence of the House is not a matter to be determined by the governor or, for that matter, anywhere else except the floor of the House, correct? Principle of democracy underlying our Constitution necessarily means that any such question should be decided on the floor of the House. The House is the place where the democracy is in action. It is not for the governor to determine the said question on his own or his own verification, which is what exactly he did by recognizing a faction. Now, let's kindly come to para 32. Thus, S.R. Bommai is not an authority for the proposition that the governor must order a floor test whenever a claim is made that the elected government has lost the confidence of the House, irrespective of whether such claim is based on unconstitutional or extraneous considerations. Rather, S.R. Bommai, it was categorically held that the power under 356 cannot be used to... I just waste, we have a short time. My colleague has to also. I don't want to hog everything. Rather, in S.R. Bommai, it was categorically held that the power in 356 cannot be used to sort out internal differences in or intra-party problems of the ruling party. Para 82. If your lordships will just allow me to show that, if it's convenient. Well, I'll show that here. Volume 2.
There's Bommai?
Yes.
We'll read Bommai here. You've extracted it.
Yeah, I've extracted it.
Yeah, we'll read it from your extract. Much easier. We've got Bommai, of course.
Yes, I purposely did it, Mala, so that otherwise you'll have
we don't have to go back and forth at all.
You have extracted it also.
Yes, I've extracted it. It's okay. Well, it's actually, I must give credit to my colleagues.
Yes.
Well, it's Mr. Tiwari, Mr. Devdutt, how wonderfully they have prepared this case. It's extraordinary. And I owe gratitude, sense of gratitude to them. Sort out internal differences or inter-party problems of the ruling party, and that exercise of this power for a purpose extraneous or irrelevant to the one for which it has been conferred by the Constitution would be vitiated by legal malafides. You're now looking at an intra-party dispute. They have come to you, they are 34, I recognize you, I recognize the leader because he's the leader. So the governor is I'm sorry.
Mr. Will just give us a moment. There was an urgent order which
No.
I'll just show it to my learned brother Justice Narasimha.
That's the morning,
yes.
Yes, sir. Okay.
24th March only. Thanks. Approved that vote.
And this intra-party quotation is from Sarkari Amalats. It is adopted by Bommai. And it is consistent with those propositions, Malats, that I read to your lordships of Sarkari Amalats adopted by Rameshwar Prasad. See, you can't enter into an moment you say, okay, I'll recognize these three people, I will entertain these two people, and then now you have lost majority, now you have a floor test. Impermissible. That's the old non-10th schedule regime, the Ayagram, Gayaram regime. Then, crucially, para 34, S.R. Bommai, Justice Jeevan Reddy further observed in the context of the 10th schedule that we're equally of the opinion that the High Court was in error in holding that the enactment of a 10th schedule of the Constitution has not made any difference. The very object of the 10th schedule is to prevent and discourage foreclosing and defections, which at the time had assumed alarming proportions. Whatever may be his personal predilections, a legislator elected on the ticket of a party is bound to support that party in case of a division or vote of confidence in the House, unless he is prepared to forego his membership of the House. The 10th schedule was designed precisely to counteract horse trading. Except in the case of a split, a legislature has to report his party willy-nilly.
Mr. Sibyl, the only problem is, I just looking at it from this point of view, the basic principle of parliamentary democracy is that a government has to be accountable to and must have the faith of the House. Now, suppose a group of, say, the government has X number of legislators, and take a hypothetical case where X divided by 2, say that we have no faith in this government, though we were elected on their ticket.
Correct.
They say that, look, okay, we incur the disqualification, but we don't have faith in this government. Now, going by your logic, the governor can never call a trust vote because he will say, look, you have been elected as members of the House. You can't say that you have lost faith in the. Which case, even though the government now really effectively has only X by 2 of its confidence in the House, the strength in the House, still the government must continue. The government has to continue. It's basically reduced to a complete minority, probably.
Your Lordship is absolutely right. May I answer that, Malaz? The session is on. Finance bill has to be passed. Vote against it. Government will fall. What's the problem? This is not an insurmountable legal issue, Malaz. Any vote against it. But what they want is, they want to topple the government, become the chief minister, then tell your lordships, now the speaker will decide. This is not constitutionally permissible. Your lordship is absolutely right. What time does the government lose majority, lose confidence of the House, Malaz? At the time when it is reduced to a minority. At what time does it reduce to a minority? When they vote against the government. It is reduced. That's the solution. Till the time they vote against and the government becomes a minority, it's accountable to the people. The governor cannot assume that they have lost majority, therefore there is no accountability. That's not permissible as far as the governor is concerned. That's respectfully the responsibility to the query that your lordship raised. Prime Minister Nasim Rao ran the minority government. It's not as if governments can't be run by minorities. Point is, they don't want to lose the membership of the House. It's a double whammy, Millers. You lose the membership, you don't become a minister. You have to fight an election. You may win, you may not win. Here, you topple the government to become a minister, you become a chief minister. Use the governor's office for that. Your Lordship, Millers, I don't have to say anything more. My political experience and your judicial experience, Millers. We have reduced ourselves to that we are mocked. People don't believe us anymore. Anyway, so
now we go on to Shivraj Singh.
Then Shivraj. Respondents relied on the law in Shivraj to contend that where the governor has reason to believe that the incumbent government does not possess the support of the majority, the correct course of action would be for the governor to call upon the chief minister to face the assembly and to establish the majority of the incumbent government within the shortest possible time, irrespective of the fact of disqualification. Well, I just read the highlighted portion. Undoubtedly, the purpose of entrusting such a function to the governor is not to destabilize an existing government. Well, as I read the beginning, as a matter of constitutional law, it would not be correct to proceed on the basis that the constitutional authority entrusted to the governor to require the Council of Ministers to prove their majority on the floor of the House can only be exercised on the very inception after general elections are held, and not when the governor has objective reasons to believe that the incumbent government does not command the confidence of the House. The governor is not denuded of the power to order a floor test, where on the basis of the material available to the governor, it becomes evident that the issue as to whether the government commands confidence of the House requires to be assessed on the basis of, a floor test. Undoubtedly, the purpose of entrusting such a function to the governor is not to destabilize an existing government. When the satisfaction on the basis of which the governor has ordered a floor test is called into question, the decision of the governor is not immune from judicial review. The court would be justified in scrutinizing whether the governor prima facie had relevant and germane material to order a floor test to be conducted. So we are not against the floor test, we're against the considerations on the basis of which the floor test was ordered. It is respectfully submitted that Shivraj Chauhan, there are no disqualification petitions. Now, this is the other thing, pending against the MLAs whose resignation was under consideration. As noted by the Honorable Court in para 41, notices of disqualification had been issued against 6 MLAs on 13/3, but the Speaker had accepted the resignation of these 6 MLAs on 14/3, which I mentioned to your Lordships yesterday. As regards the other 16 who had tendered their resignations, the Speaker had not yet accepted the resignations. When the Governor directed a floor test to be held, the disqualification petitions were not pending against MLAs whose resignations were under consideration when the floor test was held. On the other hand, in the present case, Governor's decision to direct a floor test to be held on 20, knowing full well that the very MLAs of Shivsena legislative party who the Governor had recognized are facing disqualification. Furthermore, this Honorable Court's observation in para 80, the pendency of proceedings before the Speaker cannot be a valid basis to not have the confidence of the House in the government determined by the convening of a floor test, are premised on the constitutional principle that neither the Court nor the Governor has any right to impinge on the Speaker's power to decide on the issue of disqualification. This Court cannot say that you cannot decide or I give 10 more days or 10, 15 days. That's not the power. That's not the function of the Court. It is trite law that neither the Governor nor, for that matter, this Court has the power to impinge upon the authority of the Speaker to take a decision on the above issues. Well, that's now 5 judges have said that. Therefore, that order on the 27th put us in a situation, where the elected government was toppled. Neither the Governor nor, for that matter, the Court can entrench upon the power of the Speaker, which is why I pointed out paragraph 6 of the 10th schedule and 180. Because there can't be any hiatus. Speaker's function must continue, and there cannot be any Kitemek order. Then, whereas in the present case, the decision to hold the floor test was taken by the Governor on 28/6, by which time this Honorable Court had already interdicted the disqualification proceedings against the respondents on 27/6. The Governor, being aware of the pendency of the disqualification petitions and being aware of the fact that this Honorable Court had extended the period of filing a reply on 2012, could not have disturbed the status quo in the Assembly by directing a floor test. Para 82 of this Honorable Court noted, nothing prevents the Speaker from taking a decision either on matters of resignation or of disqualification despite convening the trust vote. Even in Shivraj Chauhan, your Lordship said, because there was no interdiction there. So the Court said, in Shivraj Chauhan, the Speaker could easily disqualify. But in this case, what happened? The Speaker could not move. So how does Shivraj Chauhan, an authority for the proposition that a floor test is necessary in these circumstances? The illegality of the Governor's decision on 28/6 cannot be remedied by subsequent event or actions. The respondents have sought to justify the Governor's decision dated so-and-so by relying on Uddhav Thackeray's resignation on 29/6 instead of facing the floor test. Further, it has been contended that even the votes of 42 MLAs were excluded. We are still through. That's not relevant. When Bomai was decided and Bomai set aside orders under Article 356, what did Bomai say? Bomai said, we have to restore the status quo ante. It doesn't matter what happened thereafter. I'll show those mullahs when I come to that. Bomai said so. Shivraj Chauhan also said so. We're not asking your Lordship that what Bomai said was the acts that have happened in between can be validated by the Court. Right? Because there's legislation that is passed, there are other things that have happened. Those acts will be validated in your final decision making. But we cannot say that we can't have the status quo ante. Status quo ante, that's how Arunachal Mullahs was decided, how it was decided. Only on that basis. Status quo ante was restored. It also happened in Uttarakhand Mullahs when this court restored the Chief Minister Mullahs by setting aside the order of the Governor. So we are not saying, Mullahs, that everything that happened thereafter is illegal. No, we are saying that's the molding of the relief as and when your Lordships decide one way or the other. Anyway, Mullahs, I'll just quickly now. Then Mallards, kindly come to 46. S.R. Bomai and Union, the court, while considering the legality of a presidential proclamation under 356 that has been subsequently approved by both houses of parliament, held that an invalid proclamation would nevertheless have to be set aside. So this argument, Mallards, that is according to an argument of frustration. Because you are now saying, look, subsequent events have happened. I am the chief minister. I am enjoying the fruits of power. Please don't do anything. Now there is confidence in me in the House. All irrelevant. Bomai says so. Held that an invalid proclamation would nevertheless have to be set aside, thereby recognizing the principle that the legality of an act must be tested on its own terms, and acts consequent thereto cannot give the color of legality to an action which is illegal. I've given the paragraphs, Mallards. Further, Bomai holds that upon invalidation of the proclamation under 356, the natural consequence is to restore the status quo ante. Court may, however, mold the relief in respect of subsequent acts, but when restoring the status quo ante, the court must restore the Council of Ministers and the Legislative Assembly as they stood on the date of the issuance of the proclamation. Otherwise, the remedy of judicial review would be rendered meaningless. How much more eloquent can the court be on this matter? In fact, Bomai goes on to say that holding of fresh elections can also be injuncted on the principle that such a relief is to prevent the frustration of the constitutional remedy. It further goes on to say that the court may be duty-bound to give an interim order of this nature to make effective the constitutional remedy of judicial review and to prevent the emasculation of the Constitution. Well, what's the point, Mallards, of now saying these consequential acts have happened, so you have no judicial remedy, even though the act may be illegal? Additionally, Mallards, additionally, it is settled law that the village, let's leave that out, Mallards. So, Mallards, para 52, the legality of the governor's decision has to be determined with reference to the decision itself, not by reference to any subsequent events or facts. There is no constitutional basis for the proposition that the otherwise illegal decision of the governor can be justified by referring to subsequent events and actions, including the fact that the petitioner participated in the floor test on the 4th of July. Then governor's decision on 30th of June to swear Eknath Shinde. That's the next. It is respectfully submitted that governor does not have the power to invite a leader of a faction of a legislative party, acting dehorse the political party. But where does the governor get this power from? Who is he recognizing? Leader of what? The governor can only deal with the legislature party. He can't pick out Eknath Shinde and say, now you become the chief minister. It's like saying that the party is registered with the Election Commission. The leader is as communicated to the Election Commission, but I, as governor, will pick up another leader contrary to what is communicated to me. The leader continues to be Mallards. In the instant case, it is undisputed that on the 30th of June, Uddhav Thackeray was the leader of the Shivsena political party. However, the governor extended an invitation to form the government of Shinde, whose only claim as on 30th June was that he is the leader of the majority faction of the Shivsena legislature party. The governor, as on 30th of June, did not and could not have recognized Mr. Shinde as a leader of the Shivsena political party. As submitted above, a parliamentary democracy only recognizes alliances between political parties and not an alliance between a political party and a faction of the legislature. I've already said that. As submitted above, therefore, the governor's action of inviting Shinde Mallards to form a government illegitimately recognized an alliance between a faction and Shivsena legislative party and the BJP, which is constitutionally impermissible. The governor's decision is liable to be set aside on this basis. Further, the respondents have failed to deal with the petitioner's reliance on 164(1)(b). Mallards, let's leave that out for the moment. Let's leave out the other things. Then, Mallards, they relied upon Kuldeep Bishnoi. What I have now done is, Mallards, I've given our lordships para 62, what Kuldeep Bishnoi held and how it's wholly irrelevant, Mallards. So that I don't have to, Mallards, unnecessarily take your lordships. I've put it out in the note itself. And then Shivraj Chauhan. Then come to respondents now. This is the next topic. Next topic is page 20. Item C, respondents based on undisputed facts on record have incurred disqualification under 2(1)(a). Petitioners have shown that the undisputed facts of the respondents, namely so-and-so, passing a parallel resolutions. I will let Dr. Singhvi actually deal with this because originally also he had dealt with it. So let's sort of. Then C1, repeated, now respondents contend that now repeatedly saying that there's been a split and you have not merged is of no consequence because there is no one, this is no one's case. I have never argued that I have split from the political party. I'm just quoting from the transcript, how useful this transcript is. I have never argued that I have split from the political party. We have never argued that we needed to merge with other parties. Those were defenses under the 10th schedule. Our consistent and continuous argument has been that we are within the Shivsena, represent the rival faction. Now he's accepting it. Representing the rival faction, which ought to be recognized as a political party. Now, this is the cat is out of the bag. Now he is saying outside the constitution, outside the principles of constitutional law, a faction in the legislative party should be recognized as a political party. Without going to the election commission, without registering yourself, what political party? So I'm quoting only from the transcript. And has now been recognized as a political party is in question is in this matter. Then, I've said the contentions of the respondents never claimed that they are a faction of the legislature, but they are a political party itself is totally misconceived. After the deletion of para 3, a faction, I've already said that. Effect of deletion is that a faction, as soon as it indulges in prohibitive conduct under para 2, would have no defense available. So they have no defense available. Respondents' justification in substance is that they are the majority faction in the legislature party, which is no justification in the eyes of law. Respondents cannot avoid the inevitable consequence of disqualification. Legality of respondents' actions is to be tested based on substance and actual effect on the impugned acts. I will not deal with it. Now, let's forget about this election commission for the moment. Now come to C3 at page 22. Erroneous conflation of legislature party and political party. I just don't understand on what basis my learned friend made this submission. The whole purpose of the 10th schedule is to talk of the legislative party and the political party as separate entities. And to prevent acts which would amount to disqualification. That's the whole purpose. The Constitution doesn't recognize that. Even the Representation of People Act doesn't recognize the legislature party. It is only in the 10th schedule because you wanted to prevent acts of disqualification. In furtherance of their smokescreen defense of being in Shivsena, the respondents have repeatedly asserted that there is no distinction between a legislative party and a political party. And again, quote from the transcript, we have consistently said so, that a legislature party is integral and originally connected and co-joined to a political party. What's the basis of this submission? And I still say, I am the original political party. So first he says, I'm a faction. Now he says, I am the original political party. Because that faction should be recognized by the governor as the original political party. Now they are presuming that this is only a rival faction. He just said that it's a faction within the legislature party and not a rival faction within the political party. Whereas your lordships have time and again said, you can't segregate the two. A legislature party is also an extension of the political party. That is how it has been right through the whole artificial distinction which has been drawn, that is that the legislature party who did it and the political party had nothing to do with it. I have never ever said that the two are different. Our argument right through has been the decision of the legislature party has the authority of the political party. Where does he get that from? Decision of the legislative party has the authority of the political party, unless he says, my faction is the political party. Thus, in substance, the respondents contend that the faction representing a majority of the legislative party is deemed to be the political party without regard to the political party which has been registered by the Election Commission under 29A. A fortiori, therefore, without referring to the original political party, which has been registered with the Election Commission, the majority faction contend that they can hold themselves out as a political party and take actions within the House, dehorse the political party on whose ticket they were elected. It is submitted that a majority faction cannot claim that they are the political party registered with the Election Commission under 29A of the Representation of Peoples Act. There is nothing in law which allows such a claim to be made. Distinction between the legislature party and the political party is reflected in the provisions of the 10th schedule. Submission of Eknath Shinde Group is contrary to the clear provisions of paragraph 1 and paragraph 2 and the explanation. I have read it to your lordships, but I will not trouble your lordships with that. Then I will come to Namalas para 83, if the respondent submissions were correct or were to be accepted, it would create chaos within the political system with functions within the scheme of the Constitution as provided for in its various provisions, including the 10th schedule. So, Mullahs, now come to C4. I will leave the rest, Mullahs. Now, Mullahs, your lordships will remember all this happened much before the matter went to the Election Commission, because there they moved on 19th July. So, Mullahs, all this is so per se unconstitutional. Now come to right to dissent. The respondents have claimed that the 10th schedule cannot be used to stifle dissent within the party, and definitely internal dissent does not amount to voluntarily giving up membership of the party. Well, this whole argument was raised in Kyoto in the context of Article 105 of the Constitution, not in any other context, and was rejected. And 105 of the Constitution, Mullahs, I'll just quickly read it to your lordships. It says, subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in Parliament. Rejected. Why? Because you are a representative of the political party and bound by the discipline of that party. You have no independent right. Unlike Parliament in England, unlike the Senate and the House, and unlike European Parliament. Respondents have claimed the 10th schedule cannot be used to stifle dissent. Then at the outset, it is respectfully submitted the said contention is in complete violation of the decision in Kyoto, where this court specifically considered and rejected the argument that provisions of the 10th schedule violate the freedom of speech and conscience of the legislatures. It was held that people have grown distrustful of the emotive political exultations that such floor crossings belong to the sacred area of freedom of conscience or of the right to dissent or of intellectual freedom. This court is distrustful of that, is what Kyoto says. The 10th schedule, it is urged, negates those very fundamental assumptions of parliamentary democracy, of freedom of speech, of the right of dissent, and the freedom of conscience. This was urged by Mr. Jethmalani. It is urged that this unprincipled political defections may be an evil, but it will be the beginning of much greater evils of the remedies graver than the disease itself were adopted. 10th schedule, they say, seeks to throw away the baby with the bathwater. So, Mullahs, all this I don't have to go through. And then, Mullahs, this went on. I will not trouble your lordships. Kindly come to para 44. Huh? Para 44 is what. But a political para, page 27, functions on the strength of shared beliefs. Its own political stability and social utility depends on such shared beliefs and concerted action of its members in furtherance of those commonly held principles. Any freedom of its members to vote as they please, independently of the political party's declared policies, will not only embarrass its public image and popularity, but also undermine public confidence in it, which in the ultimate analysis is its source of sustenance. And then, Mullahs, Mullahs, para 47, Mullahs, this is a quotation from Rodney Brazier. Once returned to the House of Commons, members' party expects him to be loyal. This is not entirely unfair or improper, for it is the price of the party's label which secured his election. Now, Mullahs, this loyalty is for a price which has secured him the chief ministership. if I can put it differently. Then para 49. Well, it's the highlighted portion. Unprincipled defection is a political and social evil. It is perceived as such by the legislature. People apparently have grown distrustful of the emotive political exaltations that such floor crossing belong to the sacred area of freedom of conscience, or of the right to dissent, or of the intellectual freedom. The anti-defection law seeks to recognize the practical need to place the proprieties of political and personal conduct, whose awkward erosion and grotesque manifestation have been the bane of the times. This is recognized by a constitution court. Above certain theoretical assumptions, which in reality have fallen into a morass of personal and political degradation. And this particular litigation is a shining example of that political degradation. We should, we think, defer to the legislature's wisdom and perception, saying we know the reality, and that's why the 10th schedule, that's why they must not crossing the floor must not be allowed. And then Bomai, whatever may be his personal, I've already, personal this thing, I've already read that, so I will not trouble your lords. Then, now, para, respondents based on undisputed facts on record of incurred disqualification. I will not do that. I let my learned friend deal with it. I actually mentioned it yesterday. Every act of theirs from the 21st onwards is an act in violation of 21A. Every act of theirs, which is undisputed. 21B, of course, but that's afterwards. Yes. Then, now, E is the decision of the Election Commission under para 15 cannot efface the disqualification income. But whatever may be the consequence, that disqualification has already happened. Even if the Election Commission's order is right, which is ex facie wrong, but we'll deal with it separately. This disqualification has happened. That cannot efface the disqualification. That's the purpose of this particular paragraph. So, I will. Then the order dated 27/6, interdicting proceedings before the Deputy Speaker, in effect, created a hiatus in the operation of the 10th schedule. I've already, dealt with that, so I won't trouble your lordships with that. And then the list of dates. Then the only thing I have to now, is to go back on my written submissions. On my written submissions. Original written submissions. Yes. Now, I want your lordships to look at the chapter relating to whip.
In your rejoinder?
No, my
Original
submissions,
yes.
chapter relating to whip, that is PDF page 70 in my written submissions.
70.
On mine.
70.
70. Lordships, just have a look at
Chapter 7.
Yes.
Chapter 7 on whips. And they did not address your lordships on this at all. The only thing they gave was that document which I showed to your lordships yesterday.
Only one thing which they have said about
Yes.
whip is
Yes.
that they have referred to the disqualification rules.
Yes. Oh, yes, I have to deal with that.
Perhaps you may want to.
I'm sorry, I should. In my.
Related to 3-1.
I'm going to show that immediately, That's my mistake. I should have, in my desire to finish quickly, Kindly go to those disqualification rules. There is compilation,
Rule you will have to.
Yes. Statute compilation. F. This is PDF, page 6. Thank you, for reminding me. I should have dealt with it.
You have some doubts, so.
Yes.
Yes.
Definition of leader. Your ladyship has it, my lord has it?
Yes, we have it.
Leader in relation to a legislature party means a member of the party.
What is he referring to?
He's reading Maharashtra is the same.
तो ठीक है कोई बात
First bookmark,
Page
page 2, rather 4.
516.
Definition.
तुमको भी time मिलना चाहिए।
Definition.
Oh, okay.
Yes.
Yes. Thanks.
So PDF
Yes.
6.
Yes.
Say, leader, Lordship has that now?
Definition of
Leader in relation to a legislature party means a member of the party chosen by it as its leader. Chosen by the party as its leader. Member of the party chosen by it as its leader. Complete misreading of this definition, Maharaj. And includes any other member of the party authorized by the party to act in the absence of the leader. Authorized by the party. Consistent, Maharaj, with all my contentions. This is not in the domain of the legislature party. The party chooses the leader, the party chooses the whip. So this argument that I had thrown you out, Sunil Prabhu I had thrown you out, therefore I need not have recognized Sunil Prabhu at all on the 3rd. Because I had appointed Gogavle. Amalas, yesterday, an argument was made, how could they whip act outside the house? Amalas, what were they doing in Assam? Appointing a whip outside the house? They made me a serious argument yesterday. This is a whip. How could they do it outside the house? So you're sitting in Assam in the lap of the BJP, and you are displacing a whip which is recognized by the political party and conveyed to the speaker. And these office bearers are there on the record of the register of the assembly. And you say Gogavle is the whip. I mean, it's per se voluntarily giving up membership. You say I continue to be the leader. On what ground? You've been removed on the 21st of June itself. So how are you the leader? Well, kindly look at it this way for a moment. Well, supposing I say I am the party, what should I do? I should go to the party, call a meeting. There are rules of the party. Go and establish your majority in the party, and then become the chief minister. There may be no dispute in the legislature party. Take a case, Malas, where there's no dispute in the legislature party. What would a person do if he says that, look, I am the party? He will go to the party. He can't do it any other way. Now, if you are able to galvanize the support of X number of members, there may be minority, there may be majority. And then on the basis of those numbers, you destabilize an elected government, and then go to the election commission, and on the basis of the fact of those very people who are subject to disqualification, get the symbol and then say, I have the party. Which of the two procedures would be constitutional? Constitutional law, members of the legislature can never be given primacy over the party. Can never be given. Because they are individual members, Maharaj. Group means you may actually act together, that's not relevant. So, this is one part that they relied upon. Then para 3.
3 must be read in terms of.
Yes, exactly. I was going to read that, Malas. That's at page 5. The leader of each legislature party, other than a legislative party consisting of only one member, shall within 30 days from the date of commencement of these rules, or where such legislature party is formed after such date within 30 days from the date of its formation, or in either case within such further period, as the Speaker may, for sufficient cause allow, furnish the following to the Speaker: a statement in writing containing the names of members of such legislature party, together with other particulars regarding such members as in Form 1, and the names and designations of the members of such party who have been authorized by it for communicating with the Speaker for the purposes of these rules. Clearly, Manoj.
It is in the definition also.
Yes. Then, Manoj, my Lord the Chief Justice asked a question, or one of your Lordships asked him a question. Is the whip mentioned in the form? And the answer is yes. The fact is, it is not. Kindly see the form now. He gave the answer as yes. Page 13.
Whip is by convention, is it?
Yes, absolutely. It's not even there. Party affiliation, that's all. Item 5. Date of election, date of signing of the form.
Which form is this?
This is Form 1, Malaj.
Form 1. Name of the legislature
That's
party.
all.
Name of the corresponding political party.
Yes. There's no question of whip. No question, Malaj. That's something that's appointed by the party.
Page 5.
Page 11.
Page 11, your ladyship may have. Page 11, Form 1. PDF 13. So, Malaj, it's crystal clear. Which is why, Malaj, they very strategically did not refer to all that I had said about the whip. Not mischievously, strategically. Huh? Yes, Malaj. I was on petitioner's written submissions on this, Malaj. Yeah. Petitioner's written submissions. I got it. Yeah. That's at PDF, Malaj, page 70.
It's for lunch because we'll relax a little.
Let's see, PDF, Malaj, page 70 on whips and the role of political parties.
Yes.
So, Malaj, he said there's no distinction between legislature party and political party. See the definition. Subject to provisions of paragraph 4 and 5, a member of a house belonging to any political party.
Where are you reading?
Page PDF 70 in my written submissions.
On whips and the role of political parties.
Yes. Which, Malaj, they didn't deal with it at all.
Read in detail, Mr.
I'm sorry?
Well, that one you had read very much in detail.
In fact, we've highlighted.
Originally, yes.
We've highlighted that.
I highlighted the history, how a whip was, all that I said, but they didn't deal with it at all. Their argument was, no, the legislature party appoints the whip. And they gave that document to your lordships, which is contrary itself to the record, because that's a Rajya Sabha member appointing with it. So, that's, I've done with this part of it. Now, a bit about Nabam Rebia, if your lordships will permit me. As far as Nabam Rebia is concerned, Nabam Rebia does not take into account the ambit of Article 179 of the Constitution and the concept of removal in 179. We'll see that. First, 179C.
Does
If
not
it
take into
removed from
account
it,
the concept of removal in Article 170.
Yes, removal in 179C, Malaj, not dealt with at all In that context, yes, kindly have a look. Provided that no, it's like not a no confidence for which no reasons have to be given.
May be removed from his office by a resolution of the Assembly passed by majority of all the then members of the Assembly.
Intention to move. Intention to move. Your Lordships will remember the submissions that I had made. The question of moving doesn't arise. Intention to move. So that concept, Malad, is not dealt with in Navam Rebia at all. What does Navam Rebia say on the issue of 10 members, Malad? My learned colleague, Mr. Jethmalani Malad, said that that seemed to be an erroneous interpretation. Then members means then who are members of the House at that point in time. That will exclude people who are disqualified. But Navam Rebia says, no, you can't change the status of the House, even if there are disqualification. In a sense, saying that you can't even deal. The Speaker can't deal with disqualification petitions. That's Malad's also an area where Navam Rebia Malad's did not deal with it. That's the second. And the third is, Malad, just look at this notice. Please show where the notice is. Notice which we were given. Para 235 or what?
Nibam. Navam.
No. I am talking about the concept of removal. I'm not talking about, we are not here talking about whether the article is referred to or not. We are, no, not the ground. This is the whole point. That issue was never raised. It was me. Many things you have said happened but didn't happen. So let's not go into it. But there is no discussion as to, but kindly, there's a difference between notice for removal and a mere notice without any grounds for removal. See the notice here.
Yes, can we see the notice?
Yes, that's one important. Yes, I know, I've already said that. Convenience compilation, 2 Malats. Page 62 Malats, PDF. It's very interesting.
PDF page?
Page 62 Malats.
62.
Now, Malats, kindly see. Just have a bare reading of this notice, you'll find out, Malats. You realize the fallacy of the decision in Nabam.
Running into 731 pages?
notice.
PDF page 60.
This is that one, Malats, which it is dated 21st June, but Malats received by the secretary, the secretariat at 11:33 on 22nd June.
AM.
Yes. Says you were, my lords have it?
Yes.
You were elected as Deputy Speaker of the Maharashtra Legislative Assembly in 2019. Since February 2021, due to resignation of Nana Patole from the post of Speaker, you have been discharging functions. We all respectfully submit that you no longer have a right to continue as Deputy Speaker. What kind of notice is this? For my removal? It's well-known judgment of the Supreme Court, so they rely on Navam Rebia. They misinterpret, according to me, Malad, this could not have been the law in Navam Rebia. Could never have been. They write a letter saying, now, I want to remove you. That's it. It's not a no-confidence motion. It involves, Malad's consequences, civil consequences. I am holding an office under Parliament. I am removed from that office. I am not told why I am being removed. Yes, that's why the Constitution says at the time when the Legislative Assembly is in session. Remember, I read that? At that time, if it is moved and it is under consideration, only on that occasion I cannot sit. I have to go down to the House and I can participate in the proceedings and put my point of view. The procedure itself tells you that inherently in this process are reasons for removal.
What you're saying is simply saying no longer enjoy the support of the majority of the House means nothing. This is what
Yes.
you're saying.
So Nabam Rebia has to go. It's in that context that I mentioned 179C, Malas. So, Malas, I've done with that. Now, I just want to read, Malas, their letter of the 21st of June, that resolution. Your Lordships, you just permit me. I won't take much time now. Almost done. Which way is that document? Convenience compilation 2, page. Section 2, page 55. That PDF 55, Malas.
PDF 55.
55.
55.
55?
Okay.
55. 55 only.
Is that right? No.
PDF.
PDF 55. Okay. Yes, Malas. Can you kindly have a look? Read with me this.
ये कहाँ है?
Page 42. 42 only.
42.
Yes. Page 55, volume 2, Malas.
42.
ये page 55.
Okay.
So, Malas, this, first of all, this is written when? When this group, whether it's 34 or 39, are sitting in Assam. They know on the 21st of June that Eknath Shinde has been removed. Right, Malas? So it is in that context that this document is written. So obviously it's a self-serving document. It is not a document that sees the light of the day prior to 21st of June. It doesn't talk of any event prior to 21st of June. It makes some general statements that our cadres are unhappy. It refers to no such event. It refers to no such event when he has aired his views publicly prior to 21st of June. It refers to no such communication to the Chief Minister or to the party office prior to 21st of June. It's a self-serving document to justify the switch to the BJP. On account of corruption in the government. But till the other day, till 21st June, he was the minister. And he was the group leader. No. Sorry. And corruption is not relevant, Malas, as your Lordships have already heard in Boma itself says, corruption not relevant even for 356. Forget about this. So, Malas, what's the credibility of self-serving statements of a document when you're sitting in the lap of the BJP in Assam, knowing full well that you have been removed as a group leader? And that Ajay Chaudhary has been appointed. Now, Malas, kindly see the end of this document. PDF 58. In view of the above, I'm sorry, my lords have that. In view of the above, the members of the Maharashtra Shivsena Legislature Party have met today, Legislature Party, and resolved as under, hence it is unanimously resolved as under, it is hereby resolved that, and reaffirmed that Eknath Sambhaji Shinde, who was appointed as a leader of the Shivsena Legislature Party on 31/10, is and continues to be the leader. Why continues to be the leader? He is the leader, if he is the leader, because he knows he's been removed. And then it is hereby that Bharat Gogavle elected is appointed as the chief whip, and that Sunil Prabhu's appointment is cancelled. Well, sitting in Assam, 34 people or 39 or whatever, cancel the appointment of Sunil Prabhu. Which procedural law is this? He's been the whip since 2019. So it's a self-serving document. No credence can be placed on it. There's not a mention of a split at all. It's the decision of the legislature party. So no split, self-serving document, and relied upon to show that there was some enormous discontent that was happening, reflected nowhere in the document with respect to any fact that's stated. And governor says that this document shows I am in receipt of resolution of 21st by 34 members stating that there is enormous discontent. Resolution clearly indicates that the majority members of the Shivsena legislative party want to exist the alliance of the NCP and INC, and to that end they have reaffirmed the appointment of the leader of Shivsena legislative party. He is recognizing a person who has been thrown out, the governor. With greatest respect, Manoj, this cannot be countenanced. You have to completely disregard this document as a self-serving document with no indication. And therefore, Manoj, Justice Venkachalaya's observations only, Manoj, reaffirm that we have reached the bottom of the barrel. So, Manoj, I mean, I didn't want to say this, Manoj. I really did not want to say this. But I'll give to the other side. You just have to read it, Manoj, where we are going in this country. Give it to my. Read, just send it to my. Just give it to the other side. I will not read it aloud, Manoj. This is a communication by the governor to Uddhav Thackeray. Just give me a few more minutes, I'll have done, Manoj. Give me just a few more minutes. During COVID times, and kindly come to the second page, third paragraph from the bottom. Second paragraph from the top, Manoj. The last three paragraphs, just read them, Manoj. Starting from I wonder. How does the governor write these things? This is the state of the nation. Malaj, last thing I'd like to say, and then I'm done, is that, Malaj, the history of this court is the history of celebration of the values of the Constitution. There have been occasions where, Malaj, like ADM Jabalpur, Malaj, which is in dissonance with what this court has done over the years, Malaj. I wish and hope, Malaj, because this is an equally, Malaj, significant case. It's a moment in the history of this court when the future of democracy will be determined. Malaj, I am absolutely certain that without the intervention of this court, our democracy will be in danger because no government will be allowed to survive. It is with that hope, Malaj, that I make this plea to your lordships to allow this petition and set aside the governor's order. I'm obliged to your lordship.
Thank you, Dr. Singh. Dr. Singh, we will continue at 2 o'clock.
2 o'clock.
So how long will you take? About an hour.
A little bit for Dr. Yeah, let them, Malaj.
Thank you, Mr. Sibal.
I am, Malaj, honored by that.
We'll give you an hour at 2 o'clock.
Deeply obliged.